Welcome to this free immigration help channel. Today is March 17, 2024, and we are getting into the volume 186 of me answering your immigration related questions. So let's get straight into it. The very first question is from Daniemorn 8046. My priority date is 21st May 2020, category F2A, country PH, and still so Philippines, and still no email from NBC. When is my interview date will be? So when do I expect my interview schedule? Enlighten me, please. All right, bunch of smiley faces, so I'm glad you are optimistic. That's definitely a good thing. Let's take a look at the visa bulletin and see what's going on for the Philippines for the F2A category. Because the question is about the NBC portal opening up, we're going to be looking at the graph B, which is dates for filing, and not graph A. So let's take a look what's going on the graph B for the F2A right here for the Philippines. Oh wow, looks like Philippines is current. It is current. It is current on the graph B, and you have your priority date is in May 2020. So Daniemorn, I hope I'm pronouncing your name correctly. I'm going to ask you a follow-up question. Was your I-130 petition already approved by USCIS? And if it was it already transferred to the NVC? And did you receive the email that your case has been transferred to the NVC? Now, if your petition has not been approved by USCIS just yet, I would definitely recommend reaching out to the USCIS directly and asking them, following up with them. You can submit your case inquiry through USCIS website. I actually have a video on how to do that. And if it has been already approved by USCIS and transferred to the NVC, then I would definitely recommend reaching out to the NVC. And in order to do that, you probably are familiar with the public inquiry. I would definitely do that because it is showing that for the Philippines F2A category, it is current. So, which means that as soon as your case is approved by USCIS, as soon as it is transferred to the NVC, your NVC portal should be open. So I'm thinking that your case have not been approved by USCIS, but again, let me know in a follow-up comment, and we can go and take a look at it a little bit further. But my suggestion is reach out to the USCIS because I'm pretty sure it has not been approved yet with them. So I'm going to post my response here, and we're going to move on to the next comment from Modi Boa Alu 6060. Please sir, I am from Ghana on F11, so F1 subcategory of F1. Visa category priority date is 30 September 2013. And documentarily qualified 20 December 2022. When can I get my interview scheduled, please? All right, so you're already documentarily qualified. Congratulations, that's definitely a huge step. Let's take a look at the visa bulletin. This time we're looking at the graph A because you are already documentarily qualified. We're looking at F1 because you're from Ghana. We're going to be looking at all chargeability area. So as of April 2024 visa bulletin, looks like the priority dates that are becoming current are of February 2015. So your priority date is September 2013. And we are getting right now the 2015. So you are definitely current already for a while. Almost, February to September. Let's see, September, October, November, December, January, February. So about 5 months. So about a year and 5 months, you should be current. So I'm thinking it might be something that is with the embassy, with the US Embassy in Ghana. Since you are already documentarily qualified, I would definitely recommend reaching out to the US Embassy in Ghana. Now, a lot of times, it's not guaranteed that the US Embassy will give you, an answer that you're looking for. But sometimes, and I had people, on this channel, and some of the friends that I have that reached out to U.S. Embassy and U.S. embassies around the world, and they were able to get the answers. And you can find the U.S. Embassy information on usembassy.gov. I'm gonna post that website into my response. But I think that would be your next step. Another thing that you can definitely do is you can actually submit a public inquiry form with the NVC, and that public inquiry form, I do have the video how to do that on this channel, but you can find the public inquiry form through the Department of State website where the visa bulletin is. And for this particular video, you can find the visa bulletin that is current in the description below. So just click on that. From then on, contact us, and you will be able to find that public inquiry form there. But if you're having a hard time, there is a video on this channel that explains how to do that. But as far as the U.S. Embassy in Ghana, let's see. Here you go. I'm gonna paste that link into this comment, so it is easier for you to find. There you go. So there's a U.S. Embassy in Accra, and here's their phone number. Again, if they don't give you a straightforward answer, a lot of times they can say, hey, we can't give you that information. Don't be upset. It happens, but it is definitely worth a shot. And if that does not work out, definitely submit the public inquiry form with the NVC, with the Department of State. Okay, let's move on to the next comment. Looks like a thank you from Hannah Almansoup. You're very welcome. Glad this was helpful. Moving further to the next one from Heber Bellis 916. This is how I answered. So that was on I-130. This is how I answered the not having the tax form questions. I retired in 2017 and have not worked since. I also am American national, defined as IUSC 821, and am not a government agent or taxpayer and do not volunteer to pay federal taxes. Okay, therefore I do not have any IRS forms to send you. I can send you last 3 months bank statements showing I can support me and my wife. Okay, so Heber, so you are, this is a comment on I-130, and as part of the I-130, you have to be, if you're a petitioner, you are a petitioner sponsor. So you have to establish with the NVC as part of the documentary qualification process that you are an able sponsor. Like you said, that you are able to support, yes, yourself, and of course your wife. Now, the ability to sponsor somebody obviously comes from a certain financial something. So I'm assuming, bank statements, yes, absolutely. But as far as the retirement goes, if you have the IRA, if you have any kind of social security income, if you any kind of anything coming in, you should have the tax forms. And in most cases, even if you don't have any income coming in, you are still filing the taxes and you are still having the tax returns, the tax transcripts every year. As a U.S. national, as an American citizen, as a permanent resident, it doesn't matter. If you're residing on the territory of the United States, that's going to be part of the deal. So, since you already submitted that, usually, the very first time you submit your, as a part of the documentary qualification process, the first time you submit all of the documents, they are reviewed pretty quickly. In fact, personally for me, I think it was about less than a month. I think it was like 2-3 weeks, and it was already reviewed. And I wasn't documentarily qualified. Well, the case that I was, part of wasn't documentarily qualified, particularly because of the tax documents. They are quite important whenever it comes to being a sponsor, and unfortunately, at least from my personal experience having this channel and working for an immigration attorney and seeing these cases, going through the documentary qualification process, the tax documents are taken very seriously. And again, that is in my experience. I have not seen a case become documentarily qualified without these tax documents. That is the tax statements, the tax transcripts that you get whenever you're filing, taxes with the IRS. So, since you already submitted it, just wait for the response from the NVC But I would recommend, my recommendation would be, just in case, to be on the safe side, I would reach out to a CPA, to an accountant, and see if there is anything, you know, in your situation that can be done that they can do, so that you do have these tax documents that you can file for the previous year, for this year, that you can submit and say, hey, okay, so this is my, you know, financial situation. Yes, I don't have any kind of, you know, I'm retired, I'm not working, but I still have, let's say, the IRA, let's say the Social Security Fund, money from the Social Security Fund coming in, or something along those lines. Because again, this is just from my experience, but it's better to be prepared. It's better to be, you know, on the safe side, just in case, if you are not documentarily qualified. Because like I said, from everything that I've seen, they just, you know, they just don't documentarily qualify without those tax documents. Okay, let's move on to the next one. Looks like multiple questions, comments from Dolly1980. Sir, thanks for your explanation. Excellent. I'm trying to apply I-765 for my kid under 14 years old. Could you please explain part 3, what I should choose? Option 1A or 1B or 2? Your answer would be highly appreciated. Thanks. And I'm going to read the next one. Sir, I'm applying for my kid under 14. Part 3, what option I should choose, 1A or 1B? Could you please help me? Thanks. Okay, so I-765 is an employment authorization document that allows a person to work in the United States of America legally. And I'm pretty sure at 14 years old, I don't think you even can apply for I-765. Let me take a look at that particular part of the application that you're referring to. Maybe I'm missing something, but at 14 years old, I don't think you need to apply for employment authorization document at 14 years old. So let's take a look. Let's see what's going on. So you are looking at part 3. All right, let's see part 3. Okay, here we go. Applicant's statement. Okay, so that's a statement, basically just certifying. All right, so I can read, understand English, and I have. So you're filling out the application for your child, which, again, the application, this is not the application that you need to fill out for your child. You know, to be on the safe side, I'm gonna ask you to please verify. Are you sure that that's what you're applying for? Employment authorization document that allows, you know, a person on the territory of the United States, whether they have some kind of visa, whether it's non-immigrant visa, immigrant visa, or any other status than permanent resident, that does not automatically allow a person to work legally on the territory of the United States of America. If that's what you are applying for a 14-year-old, well, your kid is under 14. So I'm pretty sure it doesn't sound like you need to do that. So please verify in the comment that that's what you are intending to do, because that just sounds like not something that you need, if that makes sense. So I'm gonna post a response, and in fact, you know what, in this response I'll just type in more information needed, just so that you're aware. And let's move on to the next one. Summer V Verk 622. Oh my god, thanks for this video. Now she can fly back home and I don't need to wait for a green card. Well, I'm glad this was helpful. You're very welcome. Let's move on to the next one from ASM HK4IH. If I am on a J1 visa, which category should I select? I do not have a salary. So that's the question on I-912, which is the a form. It's a request for the fee waiver. So you are on a J1 visa. Okay, so I can't answer your question because whenever it comes to I-912, you combine that form. It's a supplementary form that you're filing with whatever application that you are submitting for whatever it is that you're applying. So your current status does not necessarily matter, first of all. Second of all, because you're J1, which is the exchange visa, which is most of the times an exchange program that brings in, international, somebody from, from another country to the United States so that they can temporarily work in a certain career, field, path, whatever, for the purposes of exchange. That's why it's an exchange program. So, with that being said, technically having a J1 visa, you should have a salary unless you're a trainee and you are not making any money. So, at the end of the day, it depends on what you are applying for. Whatever your status is right now is not reflective, if that makes sense, on how you file and what you should select on the I-912. It is what you are applying that works with the I-912, because I-912 is a supplementary form to what it is you are applying for, if that makes sense. So if I understood your comment correctly, if I didn't, please comment again and I'll try to get back to that. But whatever it is your status is right now, it's not really, it doesn't really depend on, unless it is asking you in the form, what is your current status? In that case, you just say exchange visitor, J1. You can type it in if it allows you to type it in. If not, usually it is a drop down, and by the visa type, J1 is a non-immigrant visa, so there might be just a simple non-immigrant visa in there. You can select that. But if it is, if it is just a type in, you can type in the J1 visa, and that should be sufficient. Okay, let's move on to the next one. From user RF8RJ2H. What of someone who got into the USVI illegally without any status and is trying to fill the asylum form but ask of his status and the I-94 number of which he does not have? Yes, because illegally entered the country. Can you tell us what to do? This is in 2024 online I-589 form. User RF, I'm afraid I can't answer questions for... I don't answer questions on this channel to people that are doing stuff illegally, if you know what I mean. Crossing the border illegally, staying illegally. If you overstayed something by accident, it happens, all right? But crossing the border illegally and then trying to find, this is not, because I'm an immigrant myself. There is thousands of immigrants on this channel that are asking questions that, I just answered people waiting from another countries for years. You see this person from Ghana here, he's been waiting for 10 years now because he's doing the process legally. All right. So that's the questions I'm gonna. This is the cases that I'm gonna contribute to and support people trying to do things legally. But whenever it comes to illegal stuff, this is not something that I work with on this channel. So unfortunately, I cannot help you with anything. All right, let's move on to the next one from Joe Mind 9277. May case I-130 F2A. I'm from Ethiopia. Birthday, March 25, 2001. Priority date, May 12, 2021. Date for filing became current, okay, on September 2021. Approval date is January 28, 2022. Paid for AOS on February 2, 2022. Documentarily copied January 17. Completed. Okay, good. January, so just recently, 2023. Final action date, September 2024. What I think will be based on the current F2A dates movement. Will I be eligible under CSPA age? Okay, great question. So let's take a look. So your birthday is March 25, 2021. So your birthday is coming up in like 8 days. Today is March 17, 2024. And you're gonna be turning, I'm sorry, my math is not the greatest. That's why I worked in the immigration law and not in the accounting. So I'm gonna need a calculator for that just to be on the safe side. I'm pretty sure you are turning 23. You should be turning 23. So you're gonna be 23 in like 8 days. All right, 23 in 8 days. And your approval date I'm assuming USCIS approval date is in 2022. So that's 2 years. Man, you're pushing it pretty close. Technically, so I'm going to explain it to you, and hopefully you can figure it out from my explanation. So whenever it comes to the CSPA, to fall under CSPA, you have to be within, they give you that extra time that your petition was pending with USCIS, and only with USCIS, whenever it comes to the 4 family preference categories. So immediate relative does not apply. It doesn't matter, as soon as the petition is submitted to USCIS, as soon as USCIS accepts the petition, that's it. The age is frozen, all right? But for all other 4 family preference categories, it doesn't, unfortunately, which I think is not fair completely. I think hopefully, Congress will look into that, and one day they get rid of that or do something that works. But as far as it is right now, CSPA, falling under CSPA, it is only that time frame for how long your petition was pending with USCIS. So your priority date is May 12th, 2021. And approval date, if I'm understanding correctly, is January 28, 2022, which is May 12th to January 2022. So it's not the whole year. It's a little bit less than a year. It's about, let's see, May is what? 5, month number 5, and then January. So that's like 7 months. So you see, you have about 7 to 8 months of that falling within CSPA that you can subtract from your current age on the day that your immigrant visa becomes available. So let's say you have a year. I'm going to give you an example, and again, hopefully you can, sit down and calculate it correctly, because my math is a disaster. Which is embarrassing, but that's why I work with, USCIS and all that stuff, paperwork and not the. But let's say you have your petition with USCIS. When you submitted the I-130, your petition was pending for a year. And let's say you are turning 22 on the day your immigrant visa becomes available. From 22 years old, you can subtract that 1 year that your petition was pending with USCIS. And if on the day the immigrant visa becomes available and your interview is scheduled, you are younger with the subtraction of that time that your petition was pending with USCIS, then you're good under CSPA. In your case, unfortunately, from what it seems like, because you are turning 23, in 8 days you're going to be 23, and your petition was pending, if I'm understanding it correctly from the dates that you provided, about 8 months, 7 months. It's not enough, unfortunately, to fall under the CSPA. But again, hopefully with my answer you can calculate, and hopefully I'm wrong with my numbers, because a lot of times I am, and hopefully you are under the CSPA, because it really is, upsetting. It really is upsetting that everything was filed on time, and you've been waiting all this time, and just as everything is finally starting to move, and you don't fall under the age, and now you have to be over 21, and now you have to be waiting under, a different category instead of what you are right now. So do some calculations, and hopefully, like I said, hopefully my calculations are wrong, but from what you commented, it doesn't sound like you will be falling under the CSPA, unfortunately. Okay, let's move on to the next one from Sindit Mahmoud 6417. Hey sir, it's me again. Hey Sindit, hope all is well. You helped me a lot before, thanks a lot for that, but now gladly I came to USA finally. Now the thing is, I came under IR2 visa while under 18. And as you know, if I come to USA while under 18 and reside with my family with at least one citizen parent, I can acquire citizenship automatically. So now I got my permanent residence green card, but didn't got my citizenship, even after fulfilling all the criteria. Now, how can I claim my citizenship while being under 18? Because September, I'll be 18, so please help me. Disregard, sir. Okay, yes, indeed. So, congratulations. I am really glad that everything went through and you're already here. So all the hardest part, is already done. But if you are looking to change your status from permanent resident to a naturalized US citizen, you have to go through the naturalization process, which for you is going to be pretty straightforward. I have a video on the form called N400, and I'm actually going to find it. In fact, the good news for you is that USCIS made a process of applying for citizenship a lot more streamlined quite recently. So you're in luck. This is what you're going to be need. So this is the page that you're going to be needing. This is what you're going to be working with. So just go through. You can find all the answers here. The form itself is available here, so you can preview the form. But the application is available to file online. So again, it is for the most part pretty straightforward process. You submit the N400. It is reviewed within a certain amount of time, depending on from which state you're filing the form. Once USCIS approves the form, they schedule the interview. You go for an interview, and they do a really simple test of English knowledge, just basic stuff, and also the civics, which is just really, really simple questions about the brief history of the United States of America, not just in the past, but what's current, so who is the vice president, who was the first president of the United States of America, what is the law of the land, and stuff like this. You can find all of this. In fact, I do have the video on the civics test on this channel as well, so you can check it out. They do come out with the updated questions, obviously, because presidents change and so far so forth. So you will have to prepare for that. You have plenty of time to do that. But this is the page you're gonna need. I'm gonna post it in my response here. And if you have any questions along the way, you are always welcome, my friend, to come back to this channel and ask them in the comments. And hopefully I'll get to that in time. All right, so I think we got time for one more comment in this video. Let's take a look, see what's going on. Comment is from Sokun Chan 1943. Sorry if I'm mispronouncing the name. Hello, sir. My I-589 receipt notice shows that receipt date is September 28, 2023. All right. But the notice date is October 18, 2023. Okay. I made a mistake in that I filed EAD 150 days count from the receipt date or receipt. Okay. Today I received a denied decision notice and asked me to file I-120B. My question, should I resubmit I-765 again or have to file I-29B? Okay, so let's see. It's annoying. I gotta say, it is really annoying. Honestly, they could have given you a break and just not reviewed your application for because you're literally what? You're 20 days. 20 days. They could have just waited for 20 days and then processed your application and then approved you and gave you an ability to legally work in the United States of America, contributing to the economy of the United States of America. Meanwhile, they're gonna waste all this time, your time and their own time, processing all of this paperwork, sending all this stuff back and forth, and now you have to redo this. It's absolutely annoying, but I have been through a similar situation and I have seen people going through a similar situation. That's why I always recommend, whenever it comes to Asylum EAD clock, give it an extra. I mean, if you have enough patience, give it extra a month, just to be sure. Because honestly, I have seen a case where the employment authorization document application was submitted way over 150 days, but it was denied. And that particular asylum office, they said that they do not count weekends. So they only count business days, which is completely ridiculous and it's plain stupid. But in your situation, in this particular instance, I would not recommend dealing with the I-120B, because whenever it comes to appeals, those they can take, 6 months, a year. There is really no there is no specific time frame whenever it comes to appeals. So they can, you can submit it and then you can wait forever. And if you do submit the appeal, it's really not recommended to resubmit the form I-765. So instead, I would recommend waiting and making sure that you are way over that 150-day mark. I know it's hard. I've been there, and it is annoying. It is hard, being patient, waiting, and not being able to work. But in order to avoid this unnecessary back and forth, all this paperwork, these unnecessary denials, give it a little bit extra time and then submit another I-765, resubmit it, and hopefully it will be approved. And sorry you're dealing with this. It is completely annoying. So hopefully it works out for you. Hopefully, I was able to help out somebody in this video. If you have any follow-up questions, you're definitely welcome to come back on this channel, ask them, and it takes me some time to get to them, but I'll try to get to as many as possible. So thank you very much for watching, everyone. God bless, and I'll see you in the next video.